Okay,
Yep,
here
we
we
are
are. All right, good afternoon. This is the Board of Standards and Appeals Public Review Session for November 9, 2020, 2 p.m. session. No public testimony will be accepted during this review session. The first item is SOC calendar, new cases. Item number 23, 25602BZ, 160 Imlay Street, Brooklyn.
Okay, I'm going to recuse from this one. So I guess that means I'll just sort of go like this.
Okay. Okay. It's an extension of time to complete construction for a previously granted variance for the conversion of a vacant 6-story manufacturing building to a residential use in a manufacturing in an M district. Actually, manufacturing building to residential use in an M district. The special permit for this expired on May 1st, 2020. Proof of service on the initial application and proof of hearing of notice to official is not required in this case. The applicant is proposing an extension of time for 3 years to May 1st, 2023 to complete construction. There were some construction related delays since the last grant was extended. And as of March 2020, over 90% of the work was completed. And further delay happened due to the moratorium imposed during COVID. Work has resumed as of August 2020. And as of October 2020, nearly 95% of the construction work has been completed. And the applicant states the estimated completion time is March 2022, including the builder's pavement plan. And please note that the builder's pavement plan was not referred in the prior extension. That was a little bit of an oversight, so that's been included, and that's what also adding to the time period. So they have provided, the applicant has provided an updated violation list and proof of payment. It shows that all violations and penalties have been resolved with DOB. There's also an updated TCO, which expires in November 2020. So I guess there will be another updated TCO that will be issued very soon. As I said, the applicant is requesting a 3-year extension to May 1st, 2023 to complete construction and update the tax lot number to be consistent with the conversion to a condominium. I have no issues with granting this extension, but I want to hear from the commissioners. Commissioner Otley-Brown?
I have no hesitance to grant this extension. I'm ready when you are.
Okay, thank you. Thank you. Commissioner Sheta?
Thank you, Vice Chair. I don't have significant comments. The only thing I haven't seen like photographs showing the interior photographs, I would say, showing the construction status. They provided some exterior photographs that show progress, but nothing interior that I have seen. This is one thing. The other thing is I haven't seen a timetable. If they can provide some photos and timetable, and I don't think these like 2 requests would delay. Like if every commissioner else is okay with that, we can just close this when I'm ready to go with that scenario.
Okay.
Thank you.
Okay. Okay. Thank you. Commissioner Shibata?
Thank you. Based on what Commissioner Sheta just said, I guess we could close today and leave it to be open for that submission for the next day on voting. Because I have, it sounds like no one else has any hesitations here. I think that might be the best way to move forward.
I agree. We could do that. I think that's doable. They probably have all the information. It was a pretty thorough analysis. Yeah. So I thought I saw some photos, but maybe I didn't tie it in with the specific photo that Commissioner Sheta is asking for. So that sounds reasonable. Okay. If
somebody else has seen these photos, I'm fine with it. But the photos I have seen were submitted on March 16. They were submitted March 16, and these are the only photos.
Right, that's the one I'm referring to. And you're saying that's still not adequate. So that's fine. We can ask them to provide a little bit more.
No, I'm saying these are exterior photos. If we can get some interior ones, that's why I'm saying I don't want to delay it. it's very, very like clear that the building is up, the work is up, there is a significant progress. But if they can provide us with some interior photos, that would be like helpful for the record as well.
Yep, I agree. I think that can be done easily by the applicant. Okay, that sounds good. Thank you. Any other comments? All right, so let's move on to the next item, please.
Item number, 24 was postponed, so item number 25 is 2509BZ, 277 Canal Street, Manhattan.
Okay, is Madam Chair back? Yes.
Yes.
Okay, so we have proof of service of on the initial application and proof of hearing of notice to officials. We also have a proof of posting in the lobby of the building. A photo was provided. We have a community board approval, approved 35-0. DOI has no issues with it. We have on file a certificate of no effect from LPC for the interior work that was completed in 2014. However, I think we need an LPC sign off for the signage, and I'll get to that in my discussion. Fire department just this morning issued a no objection letter. So please, I don't know if all the commissioners had a chance. It was just submitted like an hour ago or so. Okay. So the applicant is, this is an extension of term and waiver of board's rule for filing more than 30 days. And also requesting an amendment and to amend the application to reflect the change in the operator of the PCE from Champion Fitness to UFC Gym Soho. There is also a change in the hours of operation, and that should be reflected in the statement of facts right up front. What I would like to know is when the Champion Fitness was replaced by UFC, how long has UFC been in operation? The plan needs to show there's no change in the location. It's still going to be located on the 3rd floor of a building, which is a 3-story commercial building. The plan needs to show the exit path to the street, including the ground floor and the fire egress. The applicant, as I said, is proposing a change in the hours of operation. The prior operation, the hours of operation was Monday through Friday, 5:30 a.m. to 10 p.m., Saturday, 7 a.m. to 4 p.m., and Sunday, 9 a.m. to 4 p.m. The applicant's proposed hour of operation is 6 a.m. to 11 p.m., 7 days of the week. I don't have a problem with it. This is a commercial corridor. This is a commercial building. I don't think that should be an issue, but that it needs to be clarified in the statement of fact. With regards to the signage, the applicant's signage analysis needs to be by frontage. It's a corner lot, so the signage analysis has to be for both frontages. And as I mentioned, the elevation shows that there are banners, but if there are exterior banners, my understanding is it needs an LPC sign off for that. So that needs to be provided. Unless the applicant chooses to remove the banner, then they need to remove it and revise the plans accordingly. And also, thus far, there is no signage calculation shown in the plans. With regards to the sound attenuation, though there was a posting in the lobby, and so far we have not received any feedback from any of the occupants from the building. So that's good. That means there is no complaint. I still want to make sure that if there is any attenuation measure that this particular user has taken, then they should state it. Because I don't know what kind of an operation the prior one was and what this is. Maybe in the prior one, we didn't need any attenuation, but this being a different kind of operator and the kind of programming that is provided may generate more noise. So we need to just make sure the sound attenuation that is there is consistent with the program that is being offered and will not be an issue. The other thing I also want to make sure that the plan conforms with ADA accessibility. I'm specifically referring to the elevator. From the plan, the elevator looks a little tight. So I just kind of want to make sure it is accessible because that's the only way to get to the third floor. And there are 3 open violations, but they're not related to PCE. So those are my comments. Madam Matthias?
Yeah, just as I had mentioned to you, Madam Vice Chair, I noticed the standard notes were because the fire department had asked for the egress marking. I noticed that some of the notes were not the standard notes that we do now, so those should be corrected. I didn't ask him to do it because you said there were comments that were going to come from the board.
Okay.
So I didn't
Okay.
think it was, to keep changing the plans.
Sure, okay. Thank you. So standard notes need to be updated to our current standard.
Right, because they say local law 58 of 87, for example, is one, and that's based on the old plan, the prior plan. So we don't do that anymore.
Okay, great, thank you. Madam Chair?
No additional comments.
Okay. Commissioner Otley Brown?
Just one additional question. There is a door to a 3rd floor roof terrace. Does the PCE have use of that roof terrace? If so, what do they do and what are the hours?
Okay. Okay. Okay, thank you. Commissioner Shatta?
Thank you. Yeah, I would like that we get some sort of clarification from them regarding that there is no noise issue. The proposed includes, or the PCE includes cardiovascular machines, treadmills, bicycles. So we want to make sure that there is no noise issue here, especially when you see that they provided sound attenuation. You want to make sure that this sound attenuation system is working and working properly. This is one thing. The other thing is I was looking at the photos submitted on July 1st, 2019, and on page 4, there is an area that seems like it's a sale area. I see like shirts there. It's kind of, that's what I like inferred from these photos. It sounds like it's a sales area. So I'm not sure if this sales area is compliant with the previous grant. I haven't seen like any reference to that in the statement of fact.
Just give me a second. I'm trying to open the plan.
No, not the plan, the photos. If you look at the photos, page 4.
Right, I saw the photo. I just want to see what's in the plan. Where is it?
I did look and I couldn't see like any mention of a sale area or something like that.
I guess that's the so-called, in broad terms, the reception area.
Yes, I totally understand that. This is kind of like very close to the entrance of the PCE. But if you look at the photo, the shirts, they have like tags on them, like price tags. And I believe these like kind of shirts are for sale. So is this kind of, my comment is as follows. Is this a sales area? If yes, please explain whether this is compliant with the previous grant or not.
Well, typically, a lot of gyms that we know, they do have an accessory, like a space where they sell their products and wares, drinks, clothes, merchandise, or weights and things like that related to the programs.
Yeah,
don't-
why is that?
Yeah, I'm not sure why it should be that.
Is it just a change in the plan? I mean, if they have to change the plan, they change the plan, right?
Right. Yeah.
Or if it's just compliant, they just mentioned that it's compliant and we're done.
But that's the part I'm not sure why it should be. It's an accessory use.
No,
It's
no,
a
I
more-
think
right?
the issue is often the gyms come and they've changed the layout, right? So it's just simply, did they change their layout? That's all. It means the plan is different from the approved plan. It's not that they're not allowed to do it. It's just different from the approved plan. They often tell us, we added a workout room
Okay.
or we added showers. Chase had his hand up.
The layout is changing. The prior resolution and approval had massage. There will be no massage at this PCE.
Right.
The massage rooms have been removed, and the plans do show that there's now a free weight exercise equipment area adjacent to reception, which I assume you're seeing the retail. But the applicant should explain and maybe show on the plans where that accessory retail space is. I'd also just like to note, the vice chair mentioned that a waiver is requested. The applicant needs to state under rule 1-07.3B2, because this was filed less than 2 years of the expiration of term. The applicant needs to provide continuous use evidence and a statement with regard to substantial prejudice in the absence of a waiver.
Can you just repeat the section, the rules that you were cut off?
The board's rule 1-07.3B as in Bravo 2.
Okay, thank you. I missed that one.
Madam Chair, this is Carlo.
Mhm.
I just wanted to piggyback on something that Commissioner Otley Brown had referenced to the stair to potentially an outdoor space. I just want to just alert that this is an M15B district, and I don't believe outdoor physical cultural establishments are permitted under 7336B. So just for clarity.
Okay,
So in other words, they couldn't even if they wanted to, and the special permit isn't available for them.
Right.
Correct.
But you know, there's a rezoning.
Oh, the Soho no rezoning?
There's
Yeah,
a rezoning, there's a rezoning plan for
Soho, yeah.
Soho, and where, this is a little bit ironic, where PCEs are going to be allowed as of right in all or some. So I'm not sure what the parameters are of the PCE. So applicants should take a look at whether they fall within the rezoning area and whether or not PCEs will be allowed as of right in this district, which kind of renders this thing moot. Or shortly, right? Because it was already certified, right?
yeah,
Like last month, something like that.
yes, yes.
But also, and also they should review the supplementary use regulations to confirm whether after the rezoning, it would still be allowed as of right, because my understanding is that the enclosure requirement comes from there and is generally applicable to commercial uses.
Okay, thank you. Any other, did I go to Commissioner Shibata?
No, you did not.
No, I'm sorry.
No worries. I'm okay with this application. It's a similar use as what was before, the Champions Box and Canal Boxing, which is similar to the UFC type of use. There's no complaints in this building, and it's a commercial building. I don't have anything further to add.
Okay, thank you. Anything I missed out from the council, or? We seem to have picked up a lot of little things that we typically don't catch when we are doing PCEs. So, okay, all right.
Okay, next item is appeals calendar, continued hearing item number 26, 2018-170A, 5103 Van Dam Street, Queens.
Just give me a second. Let me open the file. Okay. So we received another set of submissions, both from DOB and also from the appellant. And at the last hearing, where we had left it was the issue around the signage facing the west side. There are two facing. Our question was around, I think everybody at that last hearing had agreed that east facing sign had enlarged. The question out there was west facing, did it enlarge or not? And And Commissioner Sheta had suggested using some structural components to kind of use that as a way to determine. The DOB kind of used similar suggestion as Commissioner Sheta's and used the horizontal members and corresponding truss plates to demonstrate that the span of the west-facing sign had increased and the structure was widened with the addition of a horizontal section since 1978, which is the New York State DOT photos. The appellant also engaged a licensed engineer to review the sign structure and confirm that a change in the aspect ratio and an increase of the west-facing sign did occur since 1978. The appellant also affirms that the surface area of the west-facing sign does not exceed 1,200 square feet, which is the maximum permitted per zoning resolution section 42-54C2. Though the appellant concludes that the size of the west-facing sign has increased, the west-facing sign precedes June 1st, 1968, effective date of any size, surface area or height limitations per zoning resolution section 42-55C1. It is smaller than the maximum surface area that was permitted by the 1940 permit. And since the sign was legally established per 1940 permit, the current sign would be considered legal. Now, that's not how I read the text. First of all, per zoning resolution section 42-55A2, new advertising signs are not permitted within 200 feet of and within view of any arterial highway, and existing signs are not permitted to be structurally altered, relocated, or reconstructed. Then we go to zoning resolution section 42-55C1 or C2, whichever is more restrictive in this case applies. Pursuant to ZR 4255C, it grants legal non-conforming use status to signs that were established prior to June 1st, 1968, regardless of the sign, that's one cutoff date, or
Regardless
November 1st,
of the, sorry, regardless of the,
Size.
of size, or the other cutoff date is November 1st, 1978, up to 1,200 square feet in surface area. Sorry, actually 79, November 1st, 79. So any sign that was established prior to 1968 could retain the extent of the sign that it existed on the day of May 31st, 1968. Or if a sign failed to be grandfathered as of 1968 cutoff date, then the sign would be limited to the extent of its size, no more than 1,200 square feet existing on November 1st, 1979. Furthermore, the non-conforming use status is granted per zoning resolution section 52-83, which says to the extent of its size, and this is also stated in 42-55C, which says the non-conforming use status is granted per zoning resolution 52-83 to the extent of its size existing on the applicable date either of those two cutoff dates, which is the 1968 or 1979. So even though on November 1st, 1979, it's saying maximum is the 1,200, but the extent of the sign that existed. So if the sign was less than 1,200, it frozen at that time, even though 1,200 is what is permitted as the maximum. And even if the sign was established prior to 1968, per zoning resolution section 42-55C, it does not permit unlawful structural alteration or reconstruction or increase in surface area after November 1st, 1979. By now, it has been established and acknowledged by the appellant that both east and west-facing signs were increased and the structure legally altered after 1979. It is irrelevant that the 1940 sign permitted an 80-foot wide by 30-foot high sign and what currently exists meets the 1,200 square foot limit. The fact that the signs were increased from the size existing on either of the cutoff dates after November 1st, 1979 is contrary to zoning resolution section 52-83 and 42-55A and C. I'm saying A and C, it's actually A or, A, which is the first one, not permitted to allow, and C. And C could be anyone, whichever is more restrictive. In this case, it would be C2. The size of both signs have been unlawfully increased after November 1st, 1979, and per zoning resolution 42-55C2, such signs must be terminated. This is how I come to that conclusion. And so, Madam Chair.
Yeah, so, I mean, I agree that all of the elements are in play, both the 4255C restrictions that say very specifically 4255C2 that says specifically that a sign erected between 1968 and 1979 whose size does not exceed 1,200 square feet in surface area. So that we're just talking about the size of the sign, not the sign structure, right? With specific dimensions of 30 feet high and 60 feet in length. So that you're very restricted on how you get to that 1,200 square feet. Shall have legal non-conforming use status as to the extent of its size existing on that date in 1979. So it's not to say, as what I understand appellant is arguing, that everyone can have a 1,200 square foot sign, even if in November 1979 you had a 600 square foot sign. So no, you would be limited to the 600 square foot sign located within view at 200 feet and within view of that arterial, right? So it's not an expansive grant. And since they're admitting that the size of the sign increased between its original installation prior to 1979 and today, it doesn't comply with section 4255C, and we're done. We don't really actually need to go any further than that. And what my problem with the case previously was the photographs were very difficult to see. You know, they were kind of blurry and all of that stuff. And so it was Commissioner Sheta who figured out this sort of, I don't want to say logarithmic, but or geometrical analysis to figure out how many vertical supports and so on. Because I couldn't tell without a doubt that the sign had or hadn't enlarged, right? But now it appears that appellant is even agreeing that the sign was enlarged, and DOB provides material reinforcing its own argument that the sign surface area of the sign was enlarged independent of the structure, right? So I think it's almost like the appellant is conceding that it doesn't have a non-conforming sign.
Yeah, you know, and that's something I want to, I was looking through the City Planning Commission report when the subsection C was added to 4255. And there's a footnote in that. It says that by the term advertising sign, the commissioner intends to include both the message and the structure.
Oh, but it didn't say it, so.
No.
Unless it redefines the word surface area, which by the way, we've been down that path, right? Unless it redefines surface area is the outer contours of the sign. So not the structure on which it sits. Right?
Yeah. I mean, it's not relevant in this case, but.
Yes. Mm-hmm.
I have a very quick question about the analysis that is going on here. So basically the board or under your reading of the statute, even if it were granted lawful nonconforming use status as of 1979, because of the illegal construction that happened afterwards, increasing the amount of surface area, they essentially abandoned any nonconformity that would have been granted by the text amendment in 1979.
That's right. You said it very well. Yes.
Thank you,
Okay.
Kurt.
And to just make it clearer how we got to that conclusion, you can read that from 4255C2, but you can also read that in 4255A2. It says no advertising sign shall be allowed, nor shall an existing advertising sign, which is what we're talking about, be structurally altered, relocated, or reconstructed. So they're talking about an advertising sign. This is quite confusing, right? But it's the structural alteration of the sign. Like, what do they mean by the sign? Is that the structure? So this is one of those arguably interpretive things. But if you were just looking at the sign itself within the surface area, then you're talking about an alteration of the surface area of the sign.
Okay. All right. Thank you. Commissioner Otley-Brown?
I agree with the chair and the vice chair on the fact that the new DOB analysis was very helpful in showing that both the sign face and the structure had enlarged since 1979. And so I agree that as per ZR section 42-55A, which prohibits the alteration, relocation, or reconstruction of any sign after 1979, this sign no longer has conforming use status. It's now non-conforming and has to be removed. And they agree as well.
Mm-hmm. Thank you. Commissioner Shatter?
Thank you. Yeah, I'm glad that apparently we got to a conclusion on this case finally. I just want to address one additional point. It's a different aspect looking at what was discussed during the last hearing. Last hearing, the applicant tended to argue that structural alteration could be allowed in form of some emergency repairs, and from the perspective of the common sense, I would say the board members, in addition to the DOB, tended to be sympathetic with that argument. But I don't think, and I want to make this very crystal clear, at least from my side, I don't believe that the structural alterations that were done on these two signs were emergency repairs. The reason for that, it's very similar to this case. I'm a structural engineer, and let's say somebody has a building that's deteriorating and it needs emergency repair for the foundation, let's say. If this somebody go and do, let's say, underpinning or put some additional foundation elements and come to me, and I'm the agency that has jurisdiction over that building, and says, you know what, I didn't get a chance to pull a permit. I did this worker rush. It was an emergency repair. I would think of that as follows. If he didn't increase the load in the building, just did put some additional supporting elements, I would be tending to believe that what he's saying is legitimate. But if he tells me that, you know what, I had to do this kind of underpinning work, foundation strengthening, and in the meantime, he added 2 floors, then I would say, no, I don't believe you, because it sounds like the main reason for the work you've done is to put additional floor for the underpinning or the foundation strengthening is to add some floors. Very similar here. If these 2 signs were like that, if I looked at the supporting structure and I have seen some changes in the gust plates of the structure and the spanning and the bay lengths and these kind of things that I looked at during the last hearing, without significant or without apparent increase in the size of the sign itself, I would say, yeah, maybe they have a point. Maybe they did this as an emergency repair. But in this case, the sign itself was increased. The size of the sign was increased, which means that the reason for whatever structural repair done or alternation done was not to save the day for the structural status of the sign. It was to increase the size of it. And I just wanted to make this clear because it might be argued later. So that being said, the two signs were increased in size, and this is like in violation of the ZR. I believe we're done.
Thank you. Commissioner Shabeta?
Thank you, Vice Chair. I agree. I don't believe there's much more argument that can be made. They conceded that the size is greater than it was. I want to first commend DOB. I think they did a great job, a great analysis. They really answered our questions from the last hearing. I too was on the side that I didn't see it different. I was concerned because of the angle of whether or not I was comfortable saying that this sign in Fayette became larger. DOB had certainly completely freed me from that concern, and so much so that the applicant had to acknowledge that this side has in fact changed. And while I appreciate the last-ditch effort of trying to find some way to keep this sign, I think we can all agree that 4255 settles this issue for us. The sign has changed past its date, and that should be the end of that.
You know, thank you. I go by this site very often, and I can't tell you how many times I've taken photos of this site trying to get that angle. But whatever I see and I try to capture it, I cannot do it. But one of the things that bothers me is the sign, the west-facing sign that is extended. I think, and this is based on my angle of viewing when I'm on the highway, and I have stopped early in the morning just to see what I'm seeing and nudge, nudge, nudge with the blinker on. The portion of the structure is sitting on the bulkhead, on the rightmost bulkhead, which wasn't there as part of the 78 DOT photo. So that to me is a little bit bothersome. But I couldn't take any photos to prove it or justify it. Anyway.
Well, I found your photos helpful, Chair.
Yeah, what do you mean what's bothersome?
That the structure is sitting, the edge of the last structural edge, the back of it, is sitting right on the bulkhead of the stair bulkhead that is on Van Dam.
So what's bothersome?
It's the structural integrity of the rest of the building and the bulkhead. That's what I'm concerned about, and the fire safety issues.
Okay.
Yeah.
In other words, that it might be obstructing egress to the roof or access.
Yeah.
From
Yep. 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 So, you know, and this is something, bless you, this is something I just don't understand when such applications come in. Why is it not possible for the appellant to be required to go and physically do a survey and measure the existing condition? Why do we have to go through this so much of contortion of guessing from photos?
Well, some of it is, I do have to say, we need the photos because there was no survey done in 1978. If there had been a survey, I mean, I would have to say DOB is listening, right? Going forward, they should, where there are these kinds of grandparenting clauses, require surveys of the existing condition so that in some future time, a survey can prove the same conditions, right? But in the absence of a survey from 1979, the survey today would only tell us what today's conditions are. They wouldn't tell us what it was then. So you're using the photos from 79 and today to see if you can make a comparison, and then using all of this geometry. And actually, what I remember really well was when our now general counsel, Kurt Steinhaus, was appearing on behalf of DOB. He used all kinds of triangulation triangularization, is that the word? Triangulations?
Triangulation.
In order to determine the size of the sign based on different vantage points and so on, just basically using geometry, you know, measuring from star charts, because we
Yeah.
don't have that.
Right. All right.
Okay.
Commissioner Otley Brown, do you have anything to say? No. Okay. All right.
Okay.
Anything else? Anyone needs to add? Okay.
Yeah.
I think then we
Okay.
can move on to the public here.
This concludes the public review session for 2 p.m. November 9th. We now commence with the public hearing. So this is the Board of Standards and Appeals public hearing, November 9th, 2020 at 2 p.m. session. The first item is 23-25602BZ, 160 Imlay Street, Brooklyn. Oh, why does this keep coming up? Oh. So who is here? Is it going to be Shelley or Elena? I don't know.
We're waiting for Shelley Friedman.
Okay.
And Massimiliano Sinise is also registered.
Okay. I guess Antonio Dioronzo or Gerard Kaplan and Timothy McCranen are not for this.
I don't know.
I just emailed the applicant.
Okay. Okay, we have someone else join in just now, it seems. Yes, Mr. Friedman is here. Oops, nope, he disappeared.
Okay, Shelley is there. He's muted.
Is he there?
Yeah, do you want to unmute yourself, Mr. Friedman? Thank you.
Yes. Hello. I'm sorry.
Okay. So are you're waiting for your associate to come?
We're waiting for Massimiliano Sinise to join and Joe Morale, but I'm prepared to proceed.
Madam Vice Chair, do you want to proceed or you want to wait?
Do they need to be sworn in?
Yes, they do.
Okay, let's proceed, and then if they need to contribute, then we will swear them in.
Okay, Mr. Friedman, raise your right hand. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please proceed. Madam Vice Chair, do you want to proceed or you want to wait?
Mr.
off your
Friedman,
YouTube.
can you turn off your YouTube, please? Okay, let's proceed, and then if they need to contribute, then we will swear.
Shelley, turn off your YouTube. No, Shelley, turn your YouTube off. I don't think you can hear me. Turn your YouTube off.
I do.
Okay, turn it off.
Okay. All right, well, thank you for that. Ah,
Okay,
there-
Can
Can
you
you
hear
hear
us,
us?
Mr.
Sounds
Friedman?
like it sounds like he's listening
yes,
from the
can you hear
YouTube.
me?
Yes, you
Okay.
can now
Can you hear
hear the
me?
whole thing through us, through this. You don't have to use the YouTube.
That,
Okay.
my error. I'm sorry for that.
That's okay.
Well, thank you. I hope everyone, I hope everyone is well. Shelley Friedman, representing the applicant. We listened in on the YouTube presentation, so we know your issues. I'd like to just provide two quick clarifications and then make ourselves available to answer your questions. The first has to do with the certificate of occupancy. We do have a certificate of occupancy for all of the residential portion of the building now. We received that in September. It will require updating under the usual procedures, but all of the residential units are now under a TCO. In fact, the interiors are so complete that I can report to you that of the 70 units, 22 are under contract, are sold. Another 16 are under contract, and 6 are actually occupied. So this is a very live building at this point. We understand that there's been a concern about photos of the interiors, which we will provide if the board continues to think it necessary. But I did want to point out that the entire residential portion of the building is now TCO'd and working toward substantial occupancy as of this date. We do have a schedule of remaining items on page 8 of our revised findings. I know there was a question regarding the schedule, which indicates which elements remain undone and the timeframes for those. I think the master issue there are all exterior issues, predominantly the roof and the mechanical systems. This is a very large building. Its roof is a block and a half, is by New York City grid standards, a block and a half long. So it's taken us a while and will take us a while. We believe the vice chair has more than adequately described the bases for our request. And so I'm prepared to close and answer any questions that you may have.
I just, thank you. Commissioner Sheta, did you have a chance to look at the table 2, status of work remaining as of November 2017? That's the one you're referring to, Mr. Friedman?
Yes, Vice Chair.
Okay.
Yes, I have seen that.
Okay. Is that satisfied does that satisfy the question that you had?
No, what I said is if they can provide us with some photos, that interior photos, that would be like,
okay,
just it's like housekeeping issue, just
okay,
to keep them in our records.
Okay.
But I do not mind like closing today. I'm fine
Okay,
with that.
because you had also asked for the timetable of construction. I think so this table addresses that. It's the photos that you still would like just for the record.
Yes.
Okay. Any questions that from the rest of the commissioners, Commissioner Otley-Brown, Commissioner Shabeta? Okay, I'm seeing them shaking their head. No. Okay, so let's go to the public hearing. But let's see if anybody has any public testimony. I'm sorry.
So this is 25602BZ, 160 Imlay Street, Brooklyn. So if you're calling.
There's an individual in the waiting room by the name of Antonio Di Oranzo. They're not registered, so we can admit them and see if they're here to speak for this application.
Okay.
Okay.
Hi, this is Antonio Di Oronzo. I have nothing to say at this time.
Okay.
Are you
thank
here for a different application?
No, I'm here for this application. I'm the architect of record.
Okay, thank you.
Okay.
Thank you.
Okay, so I think based on the comments, we have no issues. We can close, but Mr. Friedman, if you can just provide some photos of the interior construction status. Hello?
Be happy to.
Okay, all right.
Time frame, Mr. Friedman?
Yes, we'll be happy to.
And what's the, how long
1
do
week.
you think you would need to provide that information?
1 week.
1 week. And could you also provide the latest certificate of occupancy just for our file?
Yes.
Okay, great. So 1 week. So with that, if that's okay with everybody, we can close?
Yeah.
We didn't hear anything from anybody?
No.
All right.
So Madam Vice Chair? Motion
Yes,
to close?
yes.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Yes.
Commissioner Shabeta?
Aye.
So the application is closed, the hearing is closed.
Thank you, Mr. Friedman. Good to see you.
Very much. Be well.
Okay, bye. Okay, the next item is, item number 24 has been postponed, 23807BZ. The next item is item number 25, 2509BZ, 277 Canal Street, Manhattan.
I think I saw Mr.
This is Neil Weisbrod. Yeah, he's there. And
He
Jared,
is there, right?
yes.
Oh, no, oh, there he is, okay. And who is
Hi.
Timothy McCarranan? Is he with also Mr. Weisbrod?
No,
He's DOB counsel for the next case.
Oh, thank you, sorry.
hi, good afternoon, Vice Chair.
Swear you in. Is Jared Kaplan with you?
No,
Okay,
I'm a student at NYU.
okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
yes, I do.
Okay, please proceed.
Hi, good afternoon. I just listened to a review session and I'll go through each comment. First of all, I just want the board to know that the Soho rezoning has not been certified yet. There's a scoping meeting on December 3rd. So we also want to see what's in the revised text. It would be great if they did say that PCs were as of right, but we're still going to move forward with our application, if that's okay with the board. Regarding the changes in the hours of operation, I will revise the statement of facts to include that in the actions requested section. The UFC has been at this gym for approximately 5 years. I don't have the exact date, but I will provide that in my next submission. The plans need to show the exit path. We will revise plans. I have to go back and listen. I didn't hear exactly what was missing. Or if someone wants to tell me now, but I can always re-listen to review session.
So, yeah, so just, Mr. Weisbart, typically we ask for the exit path all the way from the floor to the street level. So we do not have the ground floor plan and all the exit routes from the third floor to the first. So please include that.
Okay. The sound attenuation, I need to check with the architect to see what sound attenuation is installed, if any, and we'll update the plans to reflect that. The same goes true with the ADA compliance. We'll show that the space is ADA compliant, and especially the elevator. We will revise to provide the BSA standard notes. The roof terrace, I don't believe the roof terrace is used for exercise purposes, but I'm still waiting for confirmation. I'll provide an update, but I understand that it can't be used as part of this PCE, so it will not be used as part of this PCE. We will include the accessory sales area on the next set of plans. The banners, we're gonna need to check with LPC, but if they're not permitted, the banners will be removed. Oh, and we'll also provide a sign analysis. Apologize, I didn't, for all frontages. I'll just put that in here. Excuse me. And finally, the waiver provision under 1.07.3.B.2 will provide proof, but I did have a question for Mr. Vine, if I could ask that question.
Please.
So if there was a small break, I don't know if this is the case, but if there was any break between Champion Fitness and UFC taking over, does that mean we're not eligible for the waiver? And this is a new case?
Just submit whatever evidence of continuous use you have and the board will review it.
Okay, so we will do that. And I think that was all the comments.
Okay. Any additional questions, comments from any of the commissioners, Madam Chair?
No.
Okay, so let's go to the public testimony.
So this application is 2509BZ, 277 Canal Street, Manhattan. And the call-in number is 646-558-8656. Zoom meeting ID number is 913-5857-4592.
While we are waiting for folks to dial in, if there's any. Also, as part of the signage, whatever signage you plan to retain, please indicate in the elevation and provide an analysis chart with it in the plan.
Okay.
Okay. How long do you think it will take you to update and provide all this information? Sound and drawings are going to be the most time consuming.
I would say 2 weeks for the submission.
2 weeks?
Yeah. I mean, there's not a lot to do on the plans, and I think we have all the information on the signage, so.
Madam Vice Chair,
Yes?
it's Carlo. Just quick clarification for Mr. Weisbard regarding your comment on LPC. Did you want something from LPC?
Well, that's up to the applicant. If they want to retain those banners, then they do need an LPC sign off. If that's going to be an additional timeline, because until we get an LPC sign off, we cannot we cannot vote on this application. If the applicant does not think it wants to go or wait that long, then it seems what I'm gathering, Mr. Weisbard, that he will remove the banners and then avoid having to go to LPC then.
Right.
That's correct.
But the other option is that the banners existed previously and LPC has already approved them. So it's more like checking whether they've received approval.
That's fair, though I have to say, I did not see the previously approved plan, did not have any banners in the elevation. There was no reference to it. And the LPC sign off from 2014 was only for the interior. There's no reference to exterior. So that's why
so there's a possibility that another retail space in the building or something had banners, in which case this PCE would be those banners. That's where you might already have approval.
Well, we'll look into that, and thanks.
Okay.
So just like a kind of heads up, though, you don't need a lot of time to submit. If you don't have LPC sign off in some version on the banners, then you would take the banners down, right?
Yes.
So then you would show photos of the banners removed, and 2 weeks may not be enough time. Because it's not just the banners. It's not just the banners that LPC looks at, it's the poles that support them. Right? That's the intervention into the building itself.
Okay. So I have no problem with a month if.
All right.
Okay, 1 month to submit.
Sounds good. Thank you.
Okay, thank you very much.
Have a good day.
You too.
Okay, the next item, appeals calendar, continued hearing item number 26, 2018-170A, 5103 Van Dam Street, Queens.
Okay, we have Mr. Kilduff. Do we have someone from?
Mr. McKiernan is from the buildings.
Okay.
Yep, I'm here.
McKernan, sorry.
Thank you, Tom.
Is Jared Kaplan here for this application?
I don't see him in there.
No, he said he's from NYU. He may be a student observer. Maybe you could let him in and let's find out.
Well, maybe he was here for the other one. No.
No,
Yeah, he's still showing on the attendee list.
Yep.
He's there.
Student
He's
observer.
there.
he's a student observer of the BSA. Welcome, Mr. Kaplan.
Thank you. Thank you.
I hope you join in tomorrow. It might be a more lively hearing.
This has been fun.
Okay, good. Okay, thanks.
Okay, the
I'm
eight
not-
case, sorry.
I'm not sure how much more fun is going to come from this one, but that's.
Okay, the eight case, we don't have to swear in, so you can proceed, Mr. Kilduff.
Thank you very much. Good morning, Madam. Good afternoon, Madam Chair, Commissioners. Patrick Kilduff, Charter, Krinsky, and Drogan for the applicant. I did view the review session a little earlier today. I really don't think there's much more for me to add at this point. We're aware of the conclusions and the views of the board with respect to the increase of the surface area of the sign on the west facing sign. We did undertake that review by the licensed engineer, as we said we would at our last hearing. That did confirm the increase in the aspect ratio, which is specifically what Commissioner Sheta had asked us to perform. And it does appear that the surface area of the west facing sign was increased. Other than just noting that this is a history of signage at this location that does go back to the issuance of the 1940 permit. We are mindful of the board's views on this, and we have nothing further to offer at this time.
Mr. McKernan?
Sure, thank you. Good afternoon. So I think it's not surprising. I totally agree with the board's analysis. I did want to make two additional points of clarification, perhaps to shore up the future BSA resolution. And one is that pursuant to 5220, there's no doubt that repairs are permitted. So I think that clarifies Commissioner Sheta's concern. The zoning resolution clearly allows repairs. And then I totally agree with Commissioner Sheta that there's no question here that what's happening was not a repair. So that provision is not applicable. And the other item that I wanted to add was just, so again, to clarify, I agree that with the board's analysis about why the 1940 permit is not relevant, but two further points of weakness in that, in appellant's argument regarding the 1940 permit. One is that appellant has not demonstrated that that was an advertising sign. And second, appellant has not proven that there was no 2-year discontinuance. I think really the evidence, the gap is from something like 1940 then to 1978. So appellant would also have to demonstrate a lack of discontinuance. So that's just another reason why the 1940 permit is not relevant here. And with that, I'm happy to answer any questions that the board has, but I think DOB and all of the commissioners are on the same page here.
I just want to point out, just from a safety point of view, as I said, from my angle of sight of this building and the sign, I'm just a little concerned about the fire safety issue. So if fire department is here, I just want them to be aware of it and make sure it's the sign is not blocking any fire access or anything. And same goes for DOB. It takes a while for the whole system to come into play and for the sign to be dismantled. But I just want to make sure that there is a tie over where it doesn't become a nuisance and a hazard.
Counsel for the applicant?
It's the sign structure, not the sign, right?
The sign structure, thank you. Yes, sign structure, yes.
Counsel for the applicant, are you planning on withdrawing the application?
At this time, Commissioner, no, we were just seeking to get the final determination of the board.
Okay. Do you want the fire department to speak?
Yes.
Sure.
John?
Yeah. You're muted.
Unmute. You're
No.
muted, John.
I heard your comments earlier during the review session, Madam Vice Chair, and Ted Ricketts and I will be visiting the site this Friday at 8 o'clock.
Okay.
Okay, thank you. That is super fast.
Okay, so do we want to close or?
I think we can close. Do we, the public testimony we'll have to take, right? We're still in public session.
Yes.
So let's go into public testimony.
Well, Madam Vice Chair?
Yes.
Well, if you close the application and if I discover that there are issues with fire safety at these premises, I have to issue violation orders. And these orders may hold up the application so they to correct it.
Well, not actually. No, sorry. If you, what's before us is kind of a determination on, it's almost like an interpretive appeal on it is, but similar to, right, on whether or not they complied with grandfathering or grandparenting standards under the zoning. And the board is not inclined, based on all the commissioners, to agree that they are not a non-conforming use. So it will render the sign basically illegal and will need to be taken down. So whatever fire department needs to do to enforce in terms of safety, it should proceed to do. The difficulty with all of these signs, and especially when you drive down the highway and you look at the signs around here, is that many of the sign structures remain and they're just frames and there are no panels on them anymore. Or if there are panels on them, they're painted, they're white or more or less just a frame, right? So the sign structure just stays up there, and I don't know what DOB's approach is to getting the structure itself taken down. And the structures certainly pose hazards because they decay, right? Or they're sitting on top of a stair bulkhead or something like that. And maybe Mr. McKiernan can enlighten us, like, what is DOB doing about the plethora of sign frames that are up where clearly the owner of the advertising panel has lost their argument with DOB, and now there's no signs up there at all. It's not even accessory business signs.
Right, I think that's a major concern. It's sort of a different branch of DOB than the General Counsel's office. We have our signs enforcement unit. I believe pursuant to the code, we have authority to perform the work ourselves, or perhaps HPD does it, and then place a lien on the property. And I think the standards there we apply are similar to our unsafe building situation. So, you know, there's a different arm of DOB, and they use their judgment to decide when it's necessary for the city to intervene. But you know, that's sort of a different branch, and to be frank, I'm not overly familiar with that, with our approach there.
It would be helpful just for the board's general information if our council and your council could get some more information on that, because it's quite confusing. You know, we look at so many sign cases and the board decides whichever way. So we're aware when we're driving down the highway, oh, wait a minute, didn't we say that sign had to be taken down? So it's true, there's no sign anymore. It doesn't even have an American flag on it or anything like that might bypass the advertising regulations. It's just a blank frame. And so maybe to give us information would be, you know, I'm speaking in-house counsel to DOB counsel, to maybe reach out and get some enlightenment on how this is handled, because it is quite confusing. And then of course we have that one case where that enormous monopole was installed and it's still in place, in spite of the fact that half of it fell over. You know, why are those things allowed to stand like that, and even though they pose a hazard? So
we will reach out to DOB counsel's office.
Thank you.
Thank you.
Is the board planning to vote as well, or to close and vote?
We close, but we don't vote during the Zoom hearings. We can't do both.
So we'll schedule it for the next
Yes.
hearing to vote. I guess we didn't hear any we didn't get any public testimonies, so we can close.
Yes.
Madam Chair,
Yes. Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta.
Thank you.
Okay, so this concludes the public hearing for November 9th, 2 p.m. session. Thank you.
Thank you,
Thank you.
everybody.
Have a good afternoon, everyone.
We'll resume tomorrow at 10 a.m.